Hello, and welcome to a news reporter's guide to a police shooting. This edition asking the question, under what circumstances is it constitutional for a police officer to shoot at a suspect that is fleeing? The intended audience for these videos are news reporters and others in the media that need background in order to fairly and accurately report on a police shooting. My name is Brian Augenthaler, and I've been representing police officers and departments my entire career, including on cases that involve the application of deadly force. This video is not being made on behalf of any client of mine, and I'm not speaking as an agent for any police officer or police department. We've already done a video describing why a police officer might shoot at a car that is being used as a weapon. And if you're not familiar with that concept, I encourage you to first watch that video and then come back to this one. I've included a link to that video in the video description below. Now we're going to talk about why the police might legally shoot a vehicle or a person that is fleeing from a scene. Under the common law enforcement could use deadly force to stop a felon if that felon was in clear flight from a scene. This was referred to as the fleeing felon rule. When this rule came into effect in the 1700s, it made a lot of sense because at that point, virtually all felonies were punishable by death. So the prospect of getting shot in the back was really no worse than the fate that might await a felon if he or she was arrested peaceably at that time. The rationale obviously doesn't hold up anymore because we have very few felonies that are punishable by death, aggravated murder being the most common example. And I also think it's interesting to note that in 1700s and 1800s, when the fleeing felon rule was in effect, the weaponry that was available to law enforcement was quite rudimentary and basic, and most conflict between law enforcement and suspects was limited to a hand-to-hand sort of struggle. It wasn't until centuries later that the prospect of ending a foot pursuit, by example, with a firearm was even a practical possibility. So in any event, the old common law rule didn't have a place in our modern society. And that's why in 1985, in a case called Tennessee versus Garner, the United States Supreme Court held that the old common law fleeing felon rule was unconstitutional. That case involved a Tennessee statute that if after giving notice of the intent to arrest, the suspect either fled or forcibly resisted, that the officer could use all means necessary to effect the arrest. And that was interpreted to include the use of deadly force. Briefly, a factual issue in Garner, a couple of Memphis police officers came upon a burglary in progress, and the alleged burglar was a guy named Edward Garner. And Mr. Garner was an 8th grader, he was 100 pounds, and he was unarmed, and he was shot in the head while attempting to flee over a chain link fence during the burglary. So the shooting officer claimed in the subsequent civil lawsuit that he was simply acting in accordance with the Tennessee statute, and the United States Supreme Court said that the Tennessee statute was unconstitutional. The law that the U.S. Supreme Court announced in Tennessee versus Garner in 1985 is the same law that binds officers today. And it's where an officer has probable cause to believe the suspect poses a threat of serious physical harm either to the officers or others. It is not constitutionally unreasonable to prevent that escape by using deadly force. So what is it that an officer has to observe in order to constitutionally shoot a fleeing felon? The Supreme Court stated in Garner that if the suspect threatens the officer with a weapon, and remember, a vehicle can be used as a deadly weapon, or if there's probable cause to believe that the suspect has committed a crime involving the inflicted or threatened infliction of serious physical harm, deadly force may be used to prevent the felon's escape, and if, where feasible, some warning has been given. So that's the modern fleeing felon rule. So let's recap real quick. To constitutionally shoot a fleeing felon, the officer must either be threatened with a weapon or the crime afoot must involve serious physical harm, and some warning must be given if feasible. So how does this play out in real life? Well, first, it's very rare to see a case involving the shooting of a felon that does not involve at least some immediate threat to the officer or the public. In other words, we don't see too many cases where the felon is merely fleeing away on foot after having committed some sort of serious violent crime like a murder and is then shot to bring the foot pursuit to an end, which is what happened in Garner minus the serious crime. It's far more common for the Tennessee versus Garner situation to arise in the context of a car chase. The officers in a car chase are frequently faced with a life and death decision. The suspect is frequently cornered at the end of a car chase and begins to use his or her vehicle as a battering ram. Assuming the suspect has found his way or her way out of a blockade of police cruisers by battering them out of the way, he's just committed a number of serious felonies. Are the police justified in shooting the suspect as he passes by them, or even shooting into the rear of the window of the suspect's vehicle as the vehicle drives away? In a constitutional sense, the answer to that question is yes. The officer is justified. And the rationale is that that sort of felonious driving is going to continue to pose a deadly threat to others on the road. In terms of defending lawsuits filed against the police, the answer is a bit more complicated and is going to require an analysis of the totality of the facts and circumstances facing the officer at the time that deadly force is used. Another practical implication of defending these types of lawsuits is that a police department may very well have a more restrictive policy than what the Constitution requires. For example, the International Association of Chiefs of Police have a consensus policy that limits shooting at a moving vehicle to those circumstances when the person in the vehicle is immediately threatening the officer or another person, or when the vehicle is intentionally being used as a weapon and alternate methods of extinguishing the threat are not present. I hope this answers the question: under what circumstances is it constitutional for a police officer to shoot a suspect that is fleeing? Thank you for watching.